Welcome to Complex Conversations. In this podcast, we hope to make complex living simple by explaining the law related to sectional title schemes, homeowners associations, and other types of community schemes in South Africa. I'm Jennifer Paddock, a dual qualified lawyer and director here at Paddock's, a specialist community schemes law and training firm. Now, last week, I dealt with owner rights and sectional title schemes. And in this episode, I'll be discussing the other side of the coin, which is owner responsibilities in sectional titles. But before we get into the owner responsibilities, there are a few more owner rights that I came across while preparing for this episode that I want to share with you before we dive into the owner responsibilities. If you want to know more about owner rights, please listen to episode 5 and then listen to this one and you'll get a full picture. So in this episode, we'll be covering a few more owner rights, responsibilities of owners in relation to finances, responsibilities in relation to the scheme's rules, responsibilities in relation to sections and exclusive use areas, responsibilities in relation to the common property, and administrative responsibilities. So let's dive into a few more owner rights. It was actually amazing when I was looking through the Sectional Title Schemes Management Act and the prescribed rules to prepare for this episode, how many more rights popped out at me. So I want to share those with you now. So the first one is that owners have the right to have scheme rules which are reasonable and apply equally to the owners of all units, and that's Section 10.3 of the Sectional Title Schemes Management Act. They also have the right to initiate proceedings, that means sue, on behalf of the body corporate if they are of the opinion that the body corporate has suffered damages or loss or have been deprived of any benefit in relation to a contract entered into by the body corporate, damage to common property, any matter in relation to the land or buildings, any matter arising out of the exercise of the body corporate's powers or the performance or non-performance of its duties under the STSM Act or rules, or any claim against the developer if authorized by special resolution, or when the body corporate does not take action against an owner who does not comply with the rules, and that's Section 9.1 of the STSM Act. Owners also have the right not to have a unanimous resolution implemented if that resolution has an unfairly adverse effect on them, and that's Section 6.8 of the STSM Act. They have the right to approach the CSOS for relief if they are unable to obtain a special or unanimous resolution, and that's Section 6.9 of the STSM Act. In a new sectional title development, owners have the right not to be bound by any contracts that the developer enters into on behalf of the body corporate prior to the body corporate's first general meeting. That's Section 15.2. This is really important because I've seen many unhappy owners who think that they are bound by a contract that a developer has entered into before the first general meeting, for example, a managing agency contract, which the owners aren't happy with and didn't ratify at the AGM. So Section 15.2 of the STSM Act specifically states that no contract or obligation entered into by the developer on behalf of the body corporate before the first general meeting is binding on the body corporate unless the body corporate chooses to ratify that contract at the first general meeting. If part or all of the common property is expropriated in terms of any law, owners have the right to any compensation received by the body corporate in proportion to their participation quotas, unless otherwise agreed by the owners by unanimous resolution or otherwise determined by the CSOS. And that's Section 12.2 of the STSM Act. Owners have the right to apply to a magistrate's court for the appointment of an administrator if there is evidence of serious financial or administrative mismanagement of the body corporate. That's Section 16.1. And if an administrator is appointed, they have the right to apply to the magistrate's court to have the administrator removed from office, replaced, or to have the administrator's term extended, and that's Section 16.6. An owner may also make application to the High Court to have the affairs of the body corporate wound up, and that's Section 17.6. Owners also have the right to change their address for the services of notices by written notice to the body corporate, and they can change it to any physical, postal, or fax address in South Africa or to any email address, and that's Prescribed Management Rule 4.5. They also have the right to be notified of all general meetings, that's Prescribed Management Rule 15.1. They have the right to have all the body corporate's money held in interest-bearing accounts, that's Prescribed Management Rule 21.4. And when the trustees deviate from the maintenance, repair, and replacement plan and pay money out of the reserve fund for some purpose that was not approved in the reserve fund budget, the owners are entitled to be notified of this expenditure as soon as possible after it is made. And that's Prescribed Management Rule 24.5.4. Finally, they are entitled to install a locking or safety device to protect their section against intruders or a screen to prevent entry of animals or insects if the device or screen is soundly built and is consistent with the design, color, style, and materials approved in writing by the trustees. And that's Prescribed Conduct Rule 4.2. Okay, so that was just a bunch more rights that owners have that I didn't include in my first episode about owner rights, and I wanted to just clarify that there are more rights. And once again, this is probably not an exhaustive list. There's probably more rights in the Act and the prescribed rules that I didn't pick out as I went through. Let's move on to owner responsibilities. So I want to start this by saying that every owner in a sectional title scheme is a member of the scheme's body corporate, and that's according to Section 2.1 of the STSM Act. And as the sectional title ownership is regulated by the Sectional Title Schemes Management Act, every owner is bound to comply with its provisions relating to ownership. So an owner can't say, I didn't know that I had to do that. Ignorance of the law is absolutely no excuse. So it's really important that all sectional title owners understand their responsibilities as owners as well as their rights. So let's talk about an owner's responsibilities in relation to body corporate finances. The first and probably most important responsibility that an owner has is to pay the contributions levied upon them by the body corporate. And this is Section 3.1c and F and 3.2 and 3 of the STSM Act. Owners have to pay the levies. They're not entitled to withhold levies if they have a dispute with the body corporate or they think that the body corporate owes them money. If this is the case, they need to follow the normal legal channels, which may involve making an application to CSOS, but they must continue to pay their levies while the dispute is unresolved. Another responsibility that not all owners are aware of is that if a creditor of the body corporate, so someone that the body corporate owes money to, obtains judgment against the body corporate for payment of that money, and the body corporate fails to pay it, the creditor can join individual owners in their personal capacities as joint judgment debtors and recover the amount owing from the owners on a pro rata basis in proportion to their PQs. So if this happens, an owner has a responsibility to pay their share of the debt unless they can show that they've already paid their portion of that debt to the body corporate. And that's Section 15.1 of the STSM Act. Owners are responsible for any insurance excess amount that relates to damage to any part of the building that the owner is obliged to repair and maintain, and must furnish the body corporate with written proof from the insurer of payment within 7 days of written request. And this is Prescribed Management Rule 23.2b. Parts of the building that an owner is responsible for in terms of repair and maintenance include their section and any geyser or any water heating installation that serves their section. And that's Section 13.1c of the STSM Act and Prescribed Management Rule 31.1. Some schemes may have rules that make owners directly responsible to repair and maintain the exclusive use areas. And if this is the case, then they would also be responsible for the insurance excess amounts in relation to damage to their exclusive use area as well. Responsibilities in relation to rules. Owners are bound by the body corporate's rules, that's Section 10.4, and they must abide by them. They must also take reasonable steps to enforce compliance with the conduct rules by their tenants and other occupants of their section or exclusive use area, their employees, guests, visitors, and family members. And that's Prescribed Management Rule 3.2. They and their tenants are obliged to comply with the scheme's conduct rules, notwithstanding any provision to the contrary contained in any lease or any other grant of rights of occupancy. And that's Prescribed Conduct Rule 7.4. Responsibilities in relation to their section and exclusive use areas. So owners must maintain and repair their section in a state of good repair, and in respect of an exclusive use area, they must keep it in a neat and clean condition. That's Section 13.1c of the STSM Act. Owners must not use their section or exclusive use area or permit it to be used in a manner or for a purpose which may cause a nuisance to any occupier of a section. And that's Section 13.1e of the STSM Act and Prescribed Management Rule 30b. This means that they, their guests, or their tenants, if they are renting their section out, must not cause a nuisance. Similarly, they must not create noise likely to interfere with the peaceful enjoyment of another section or another person's peaceful enjoyment of the common property. And that's Prescribed Conduct Rule 7.1. Owners must allow any person authorized in writing by the body corporate to enter their section or exclusive use area, so they must provide access during reasonable hours and on notice, except in the case of emergency when no notice is required, for the purpose of inspecting it, maintaining it, repairing or renewing pipes, wires, cables, and ducts in the section which serve another section or sections, or the common property, or for the purpose of ensuring that the STSM Act and the body corporate rules are being followed. And this is Section 13.1a of the STSM Act. This includes allowing the trustees, the managing agent, or their duly authorized representatives to enter their section on reasonable notice to inspect it and take any action reasonably necessary to eradicate any pests and replace damaged woodwork or other materials. And that's Prescribed Conduct Rule 8.2. Owners must carry out any work ordered by a competent authority in respect of their section and pay all charges, expenses, and assessments payable in respect of their section. And that's Section 13.1b of the STSM Act. Owners must not use or allow others to use their sections or exclusive use areas for any purpose other than its intended purpose, unless the written consent of all owners is first obtained. And that's Section 13.1g and Prescribed Management Rule 30f. This often comes up when owners, for example, have a garage section and they want to convert it into a bedroom and rent it out, for example. They are not allowed to use a section for any purpose other than its intended purpose unless they get the written consent of all owners. They must not contravene any law or bylaw relating to the use of their section or their exclusive use area, and that's Prescribed Management Rule 30C1. They must not contravene the provisions of any conditions relating to the use of the building or the common property or the carrying on of a business in the building. That's Prescribed Management Rule 30C2. They must not contravene any conditions of title applicable to their sections or exclusive use areas, and that's Prescribed Management Rule 30C3. They must not make any alterations to their section or exclusive use area that are likely to impair the stability of the building or interfere with the use and enjoyment of other sections, the common property, or any exclusive use area. That's Prescribed Management Rule 30D. They must also not do anything to their section or exclusive use area that has a material negative effect on the value or utility of any other section or exclusive use area. And that's Prescribed Management Rule 30E. They must not place any structure or building improvement on an exclusive use area, which in practice constitutes an extension of the boundaries or floor area of the section without complying with the process for authorizing section extensions. But an owner can get permission to build on the exclusive use area in a way that doesn't amount to a section extension if authorized by ordinary resolution of owners. Owners must not keep an animal in their section or on the common property without the trustee's written consent, unless they have a genuine disability that requires a guide, hearing, or assistance dog, and that's Prescribed Conduct Rule 1. And owners must keep their section free of wood-destroying insects, including white ants and borer beetles, and that's Prescribed Conduct Rule 8.1. Now let's move on to owners' responsibilities in relation to the common property. So as we already mentioned earlier, owners must use and enjoy the common property in a manner so as to not interfere unreasonably with the use and enjoyment of the common property by other owners or persons lawfully on the premises. So that's Section 13(1)(d) of the STSM Act and Prescribed Management Rule 30A. Similarly, they must not obstruct the lawful use of the common property by any other person. That's Prescribed Conduct Rule 7.2. And they must take reasonable steps to ensure that their tenants, visitors, do not behave in a way that is likely to interfere with their peaceful enjoyment of another section or another person's peaceful enjoyment of the common property. So as you can see, this provision is replicated in multiple areas throughout the Act and Prescribed Rules. This blanket overarching responsibility not to create a nuisance and not to interrupt or unreasonably interfere with other people's peaceful use and enjoyment of either their sections, exclusive use areas, or other areas of common property. Now, owners must maintain, repair, and replace, when necessary, their geyser or other water heating installation that services their section or exclusive use area, regardless of the fact that the geyser or water heating device is located on common property. And where two or more owners share a geyser or water heating device, they must share the costs of that heating device pro rata. So that's Prescribed Management Rule 31.1. Owners must not leave rubbish or other materials on the common property in a way or in a place that is likely to interfere with the enjoyment of the common property by another owner or occupier. They must not, in disposing of their rubbish, adversely affect the health, hygiene, or comfort of other owners or occupiers. They must keep the municipal or other rubbish bin clean, dry, and adequately covered, and they must move their bin to the designated collection point at the designated times and collect it promptly once the rubbish has been collected. And this is Prescribed Conduct Rule 2. Now, parking. They must only park in parking bays allocated to their section. They must not park a vehicle on any part of the common property, including visitors' parking bays, without the trustee's written consent, except in the case of emergencies, and that's Prescribed Conduct Rule 3. They must not, without the trustee's written consent, make a change to the external appearance of the section or any exclusive use area allocated to them unless the change is minor and does not detract from the appearance of the section or the common property. And that's Prescribed Conduct Rule 4.1. They must not erect washing lines on the common property, hang washing, laundry, or other items in a section or any exclusive use area allocated to them if the articles are visible from another section or the common property or from outside the scheme, or display a sign, notice, billboard, or advertisement if the article is visible from another section or the common property or from outside the scheme. And that's Prescribed Conduct Rule 5. They must not, without the trustee's written consent, store a flammable substance in a section or on the common property unless the substance is used or intended for use for domestic purposes. And this does not apply to the storage of fuel or gas in a fuel tank of a vehicle, boat, generator, or engine, or fuel tank or gas cylinder kept for domestic purposes. And that's Prescribed Conduct Rule 6. And finally, an administrative responsibility. Owners must notify the body corporate of any change of ownership or occupancy in their section and of any mortgage. And this is Section 13(1)(f). So this means that they must notify the body corporate if they have sold the unit, and they must notify the body corporate every time they lease the unit to a new tenant, and they must notify the body corporate if they have taken out a mortgage bond over the unit. So I hope that's been helpful. I know it can sound a little bit in legalese because I'm using the wording in the Act and the prescribed rules, but those are a whole host of owner responsibilities in sectional title schemes. There may once again be more. This is not an exhaustive list. If you would like to learn more about sectional title scheme management, we are running a sectional title scheme manager course very soon. You can find out more details about that at courses.paddocks.co.za. And if you want access to fast legal advice, which is not formal legal advice, but more off-the-cuff general answers to your sectional title scheme management questions, you can consider joining Paddock's Club, where myself and Professor Paddock give answers within 24 hours, Monday to Friday. And you can learn more about that at club.paddocks.co.za. I'll see you next week.